So yes, I am also in support of this bill, my concern is about juvenile rehabilitation. It's well established in our law, in Rhode Island state law, that we believe in the possibility of rehabilitation for juveniles who commit crimes. We actually take more care for rehabilitation for juveniles than for older criminals. As was mentioned in previous testimony, the Supreme Court has similar concerns. They have not yet definitively ruled on this subject about whether juveniles can be sentenced to life with no chance of seeing a parole board, but they have already ruled that you cannot subject juveniles to a mandatory life sentence with no choice allowed in sentencing. So the Supreme Court has expressed some doubts about the subject of life sentencing for juveniles, and they have not yet squarely faced the issue that we're faced with today. But there is a concern about locking up juveniles without the possibility of rehabilitating them into society that both the Supreme Court and our own law have expressed. So that much is well established. I want to talk about the particular issues in this bill. I realize that there are very serious crimes that occasionally juveniles will commit, and I do think it's important to punish crimes and to deter them. However, sentencing juveniles to a life sentence and not allowing the possibility of parole doesn't do any better at deterring crime, because there is no teenager who plans and calculates differently for a 15-year sentence as opposed to a 25-year sentence or a life sentence. No juvenile says, I'm going to commit this crime if I'm only going to face 15 years in prison as opposed to a life sentence. I mean, if teenagers were able to plan ahead that much for 15 years in the future, it will be a lot easier to raise teenagers. But this is not going to affect deterrence at all. I also want to emphasize that if this bill were to pass, what would happen is not that people would be let out after 15 years, but instead what would happen is you would be able to evaluate this person who is now a grown adult, who is in their 30s or 40s or older, and evaluate whether they have changed from what they were as a teenager. And the reason why why both Rhode Island law and Supreme Court is concerned about reintegrating juveniles into society is because teenagers do change. Many people are very different in their 30s, 40s, and 50s than they were as teenagers. People do some things when they are teenagers that are very different from what they do when they are older. And I think a lot of us know that from our experience, that people can change drastically. Now, what a judge does when the judge imposes a sentence is they look at the person who's before them as they are now. They look at what the person is at the time of committing the crime. But the judge cannot possibly know whether a teenager is able to redeem themselves, whether they are able to reintegrate into society, because what they're seeing is somebody who's in a very bad state of mind at the time. But because people have the capacity to change, that's why we have the parole board, and this is especially needed for juveniles. A parole board is in a position to see what would happen, what this person is actually like in their 30s, 40s, 50s, or older, and see whether they have actually changed enough that they can reintegrate into society. And that's just a decision that the judge can't make. In a way, in fact, our current law takes away some discretion takes away some power that the judge might like to have, because sometimes judges sentence people to life and then 20 years down the road, the judge themselves realizes this person has changed, and the judge now wants this person to be let out, but the judge can't take back their decision because under our system, neither the judge nor anybody else has the power to readjust the sentence based on how this juvenile offender has now become a different person. So this bill allows that to happen. It allows us to look at the person who this former offender now is and see if they can be redeemed and brought back into society. And I think that's very sensible because there's just no way to predict that at the time of the crime and sentencing when this juvenile is a very different person. So I do support this bill. I think it does allow society to profit from this person who has redeemed themselves, perhaps, who is able to reintegrate themselves into society. It allows the victims, that the victims have decided that this person should be allowed to be released. It allows them to say that. Under current law, the victims don't even have the ability to say that to the parole board. But if this bill passes, the victims can say that. And the parole boards are our experts in deciding that. So I think this is a good bill. It goes through the right kind of process. It makes sure the person serves a significant amount of time, but after they've served that time and they've changed, there's no benefit to society or anyone else in continuing to lock them up when this person is ready to be reintegrated into society. So for those reasons, I support the bill. Thank you.